Once again, good morning and welcome to our next topic on Criminal Law 1, Articles 6 to 12. This is one of the important provisions in Criminal Law, Book 1. Okay, let's start. Article 6, felonies, consummated, frustrated, and attempted felonies. Consummated felonies, as well as those which are frustrated and attempted, are punishable under the revised penal code. And a felony is consummated when all the elements necessary for its execution and accomplishment are present. And it is frustrated when the offender performs all the acts of execution which should produce the felony as a consequence, but which nevertheless do not produce it by reason of causes independent of the will of the perpetrator. And there is an attempt when the offender commences the commission of a felony, directly or overt acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. So later on, we will discuss this one by one on what is felony, consummated felony, frustrated felonies, and attempted felonies. Now, how frustrated and attempted felonies differ from each other, or how are we going to distinguish the two felonies? Because the consummated, alam naman natin ang consummated na when you commit a crime, for example, you wanted to kill that person, so nakuha ka og knife and then you stab him to death. Okay? So that is consummated a crime. No, that is a consummated murder. But we will not call it as a consummated murder, but rather murder. Now we are going to distinguish the two important concepts on felonies, no, frustrated and attempted. Now, in frustrated murder, the accused performs all the acts of execution. So lahat ng mga all of the acts which she believes necessary to consummate the crime. So with intent to kill. So gihimo ni ang tanan para mapatay ang isa ka tao, ang isa ka person. Okay, bala naglagot siya. But death fails to follow for causes entirely apart from his will. Pero nagtuo siya na matay na, and then eventually nabuhi dayto iyahang gi stab, no, o iyahang gi tusok og kutsilyo, no. So ang iyang kaso is only frustrated murder kay wala man namatay ang person nga iyahang gi-stab. But eventually he performs all of the acts nga para mapatay niya ang tao, but then he failed to do so. Okay? Now, in attempted murder, the accused begins the commission of the crime by overt acts, but involuntarily desists from performing the other acts necessary to consummate the crime. So, he being prevented from so doing by some cause outside of his own will. So, yahan na untang stab ang person. Okay, naglagot siya. Pero, after the stabbing once, wala na niya ikaduha, ikatulo. No? Murag, ni-desist na siya. So, technically, upon the desistance, wala niya gipadayon, kaya murag natapsingan lang. And then, murag na iniabot nga police, no, during that time. But, he has an intent to kill that person, kay dagko kayahang mga lagaraw during that time. So, ang iyang kaso is only attempted murder because not all of the acts of execution are met during the overt acts, no, because of na ang police na abot pina-uptick nag-rescue dayon or may mga barangay tanod, no, para ma-prevent ang iyang execution sa crime. To give a full view of the text on the distinction between the frustrated and attempted felonies, we have in the case of people of the Philippine Islands versus Dagman et al. Okay, we have also classification of felonies. So one of these classifications is formal felonies, or those which are always consummated because the offender cannot perform the acts necessary for their execution without consummating the offense. So example of are crimes punished on the basis of the result or gravity, such as physical injuries. So physical injuries are punished as to whether they are serious, less serious, or slight. Diba? Slight, na may mga degree of physical injuries. No? Kung serious ba siya, less serious, or slight physical injury. So later on, when you go to your book 2, you are going to go deeper on what is physical injuries, kung ano siya mahitabong serious siya or less serious or slight physical injury. Okay, the degree of injury cannot be determined without first consummating the offense. So you could not determine whether it is serious, less serious, or slight without consummating the offense. Or kung wala nimo siya napasakitan. Diba? For example, imo siyang with intent to kill him or her. No? O niya, barag imo siyang gibato lang o kanang mga butang. Yan, aigo siya sa iyahang mga some part of his body or her body. So dito nimo ma-determine whether ang crime or ang degree sa crime is less serious, or slight katong the moment nga naigo siya. So dito tan-awon kung dako bang damage sa iyahang body. So kung wala nimo siya naigo, walay any na mga bruise or something nga makapamatuod nga naigo nimo siya sa mga kabuntangan nga imong gibato sa iyaha. So there will no physical injury. There will be no case of physical injury. So kailangan ma-consummate mo muna ang crime. So kailangan mahitabo sa siya nga maigo siya. Kung di siya maigo, it could not be classified as physical injury. So di pa makadetermine kung serious, less serious, or slight physical injuries. Pero anong pag managpa ka, so kung halimbawa ka nang wala siya naigo, so technically wala physical injuries na nahitabo. So kinahanglan nga maigo sa siya before ang court na determine kung serious physical injuries ba siya, less serious, or slight physical injuries. Okay? So next classification is material felonies. What is material felonies, or those which can be committed in any of the 3 stages of the execution? So whether it is consummated, whether it is frustrated felonies, or whether it is an attempted felonies. So it could be categorized or classified as material felonies. Okay, what are those crimes or felonies which cannot be committed in frustrated stage? No, like frustrated murder. No? Ano yung mga felonies? So number one of those cases na di na to siya categorized as frustrated is the crime of rape. So which can be either attempted lang or consummated. So wala tayo ginatawag na frustrated stage. Because the essence of rape is carnal knowledge. Now, what do you mean by carnal knowledge? So according to the law, carnal knowledge is an act of a man having sexual bodily connections with a woman, or in short, sexual intercourse. Okay? So hence, even consummates the crime of rape because then there is already carnal knowledge. No, na-consummate na ang crime. Kaya wala man ay pinaka-importante. And then, we have also the cases of theft, which cannot be frustrated. So wala yung frustrated stage ang kaso sa theft. Only consummated theft or theft alone or attempted theft. Okay? Okay, again, there is no crime such as frustrated theft because the moment nga there is unlawful taking of the property, kuha niya ang cellphone, for example, and then iyang gibaligya sa lain, so that is already theft, na consummate na ang crime. Okay, there is unlawful taking without the knowledge of the owner of the said cellphone. Now, what if gikuha niya ang cellphone and because nasaktan sa owner nga gikuha ang iyang cellphone sa bulsa or sa pocket, iyang gigukod, and fortunately nakuha niya ang cellphone kay murag natagak siya. So that is attempted theft. Pwede mo siya file o kasong attempted theft. Kaya wala man niya na-consummate ang crime. And then there is no such thing as frustrated. No? Kay like in murder, gihimo nimo ang tanan-tanan para mamatay siya, but then nabuhi lang gihapon siya. So that's the time na frustrated siya. And then sa theft ng good, gihimo nimo ang tanan-tanan para makuha siya. And then wala siya nakuha ang butang, attempted lang siya. No? So munang there are some cases na dili gid siya ma-categorize as frustrated, no, crime. Next, we have, okay, in the case of people of the Philippine Islands versus Dagman et al. So in this case, it appears clearly that the defendant, diri si Dagman, believed that he had performed all of the acts necessary to consummate the crime of murder. So tanang mga acts necessary to consummate the crime of murder iyang himo. No? And therefore of his own will desisted from striking further blows. So kay feel naman niya murag namatay na siguro to akong gipusil. Tama na ni. Okay? So ni prevent siya himself nga to have the further blows of his gun. And he believed that he had killed Keng Kin. Pero totoo niya, namatay na si Keng Kin. So okay na. But death did not result for reasons entirely apart from the will of the accused. So upon knowing wala din niya na patay si Keng Kin, because siguro naigura to sa some body parts or swerte lang talaga si Keng Kin. Okay? So this surely stamps the crime as frustrated murder. Okay? Gihimo man niya ang tanang acts of execution. No, tanang mga pagpamusil with intent to kill and etc. tanan-tanan. And he believed na na-consummate niya ang crime o namatay na si Keng Kin. But fortunately, nabuhi si Keng Kin. Okay, because of lucky kay si Keng Kin or itagaan pag siya kaya. na mabuhi. So that is frustrated murder. Now, if after his first blow, kung after sa unang pagpusil niya sa gun, someone had rushed to the assistance of King Kin. So nainiabot para mo assist kay King Kin. And by his efforts had prevented the accused from proceeding further in the commission of the crime. And the accused, not believing that he had performed all of the acts necessary to cause death, he would have been guilty of attempted murder. So karon kay wala man niya nabuhat yang all acts of execution, like gusto niya papusilan ito si King Kin, if this is just only a hypothetical question. So if a hypothetical situation. So if si Dagman after first blow na ay ni-assist kay King Kin, wala gipusil po siya og balik. So of course si Dagman idagan kay basig siya oro ang mapusilan, di ba? So technically wala niya nabuhatanan ang acts of execution. But still, there is murder. No, kaya naman siya intent to kill King Kin. So ang iyang kaso is attempted murder only in this case. Now, what if namatay si King Kin because of the further blows, no, sa iyang pusil? Of course, the crime is murder. So, di na natubutangan og consummated murder. Murder sa diretso. Okay? Okay, we have here examples. So, first example is one blow is gone to Pedro with an intent to kill, and Pedro died as a result thereof. So, we are going to identify whether it is consummated, frustrated, or attempted. So, number one is, okay, all acts of execution, napatay gid niya with intent to kill si Pedro. So, consummated crime. Number two, one blow his gun to Pedro with an intent to kill. After the first blow, believing that Juan consummated the crime, desisted from further blows. So, nihawa na siya kaya patay na to siya. Patay na si Pedro. Kaya na to. But Pedro did not die but hospitalized. So, ang ihang kaso is frustrated. Kay himo naman yung tanan para mamatay si Pedro, but since wala gihapon namatay si Pedro. Juan blew his gun to Pedro with an intent to kill, but Berto assisted Pedro after the first blow and managed to escape the crime scene. So kay gipusil man niya og attempt si Pedro, but since naa si Berto ni assist sa iyaha na makahawa sila sa crime scene para di maigo si Pedro or some certain like bodyguard din niya si Berto, okay? And they managed to escape the crime scene. Even though wala naigo si Pedro or slight lang yung naigaan sa ihang body parts, still, it is a murder on attempted stage. So, attempted lang siya kay wala namatay si Pedro and then na-prevent ang all acts of execution. Wala man niya na-perform tanan. So, kung wala niya na-perform tanan na mga necessary acts para mamatay ang sa katao, then that is only attempted. Okay? Number 4, Juan blew his gun to Pedro with an intent to kill, but Luis prevented Juan from doing so. It is an attempted murder, attempted stage. Next, we have Article 7. When felonies are punishable, kano sa daw punishable ang mga light felonies, mga ginagmay lang mga crimes. Light felonies are punishable only when they have been consummated, with the exception of those committed against person or property. So, ang mga light felonies, they are punishable when they are consummated. So, for example, na kung wala siya na-consummate, ang crime. So, what are those light felonies? One of the examples of light felonies is unjust vexation, no? Kung ginaanoy nimo ang tao, you're annoying someone, so it is a crime. Ginasungog-sungog nimo, ginahilabtan nimo ang buhok, ginabirik-birik nimo, so that is unjust vexation. That is a crime, no? Basig natingala mo walay natingala mo filean mo kaso. Na ay kaso sa mga naga-anoy og someone, no? And kung wala siya na-consummate, like nag-plan pa lang ka nga ako na siyang i-anoy tomorrow, and then naay nakabalo nga i-anoy i-anoy nimo siya na i-plan nga you're going to annoying someone tomorrow or in the later days. But since wala na dayon kay tungod sa ulan, then there is no crime. They are not punishable under the law because light felonies lang siya. There is no such thing as attempted unjust vexation because ano lang siya, light felonies. Okay, Article 8, conspiracy and proposal to commit felony. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefor. And a conspiracy exists when two or more persons, so you have to take note when there are two or more persons, so dili pwede nga siya lang isa. Na ay conspiracy when exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. Magsabot sila nga to commit such that heinous crimes. No, that is conspiracy. Or if three of you conspire each other to like ito na siyang kanon i-punch or bubugo na to na siya pagawa sa campus later, no? So you are conspiring each other to commit a crime. And there is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. You have to take note the conspiracy and proposal to commit felony. Okay, what are crimes mala inse? So from the word amala, evil, or inse by itself. So evil by itself, mahibaw na gid nimo nga evilous siya or heinous crime siya. Pero na murder, di na nimo kana-explain kung anong nahimo siyang kanang crimes mala inse or evil by itself, no? Kay ang pupatay palandaan og tao, that is already evil by itself. That is mala inse. No, with intent to kill someone or with intent to destroy property. That is mala inse. You have an intention. Generally, crimes mala inse are felonies punished under the revised penal code. And there are, however, crimes which, although punished under special laws, are deemed mala inse, and such as those which are mere modification of the provisions of the code, like cattle rustling, which modifies some articles on qualified theft. No? And then, now how about crimes mala prohibita? So they are acts which are made evil because there is law prohibiting the same. One of the examples is ang pagdili pagsuot og face mask during pandemic, no? Though makita nimo kung walay balaod na dili pwede in the public, dili pwede nga dili ka magsuot og face mask, then okay lang. But since there is law prohibiting the not non-wearing of face mask. So it is mala prohibita. So ang balaod ang nakapahimo sa iyaha og crime, no? Not like in mala inse na pag tanaw pa lang nimo daan sa crime, it is already a crime in itself. Evilous na daan siya, like rape cases. Isang pag walay balaod, no, regarding with rape and murder, but it is an evil by itself. But this crimes mala prohibita, ang balaod lang ang makapahimo sa ihang crime. Pero nang na sa Davao, no smoking, no, in public places. So if there's no law prohibiting that one, pwede siya. But since there is law prohibiting smoking in the public places, those are the crimes na makonsider nimo as mala prohibita. They are prohibited by the law. Okay? Now we have here felonies under Article 9 na ay na-amend. So as I have said earlier na gina-amendahan ang mga penalties. So in this case, ang na-amendahan din is the price of 40,000 because before, ano lang siya, fine not exceeding 200 pesos. So saan naman ang 200 pesos karon, di ba? Gamay makayo na. So felonies also are categorized on the degree, no? Kung ang iyang kabug-aton. We have here Article 9. Grave felonies. And grave felonies are those to which the law attaches the capital punishment or penalties which in any of their periods are afflicted. So that is in accordance with Article 25 of the Revised Penal Code. So itong mga grave offenses such as murder and rape cases. So they are categorized as grave felonies. Now, less grave felonies are those which the law punishes with penalties which in their maximum period are correctional in accordance with the above mentioned article. So, mga less grave felonies lang. Example ng kabangga ka og sakyanan, no? And then, pag naigunay mo ang bata o katong salamin na nabuak. Pero wala siya na fatal kaayo, murag na gasgasan na siya nasamad because of the accident. So, less grave felonies lang siya. Next, we have the light felonies, are those infractions of law for the commission of which a penalty of arresto minor, or a fine not exceeding 40,000 pesos, or both is provided. Now we have here Article 10. Offenses not subject to the provisions of this code. Offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. So this code shall be supplementary to such laws, unless the latter should specially provide the contrary. So that is Article 10. Now we have Article 11, justifying circumstances and circumstances which exempt from criminal liability. So this justifying circumstances, again, will exempt you from criminal liability. So wala kay liability criminally. Okay? Now, how to distinguish whether your acts or omissions are included in the justifying circumstances, or do not incur any criminal liability. So first, anyone who acts in defense of his person or rights, provided that the following circumstances concur: that there is unlawful aggression. So, depensa lang nimo imong sarili. And then reasonable necessity of the means employed to prevent or repel it. And second one is lack of sufficient provocation. So maka-raise lang daw ka og defense if these three circumstances or requisites are satisfied. No? Number two, anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters. So again, it could be justifying circumstances if anyone who acts in defense of the person or rights of his spouse, no, di gukod ang spouse o kuan, konsilyo, and then of course ikaw, dipensaan po nimo imong spouse, no, para dito siya ma-stab. And then we have ascendants, descendants, in defense of ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity in the same degrees, and those consanguinity within the fourth civil degree. So, imo lang siyang didepensaan. Though, dili ikaw ang intention sa respondent or sa accused, pero imo man gidepensaan na imo spouse or any of those of this mentioned, no, in second paragraph under Article 11. So it will be exempt from criminal liability since it is a justifying circumstances, provided that the first and second requisites, which is unlawful regression and reasonable necessity of the means employed to prevent or repel it, prescribed that its preceding circumstances are present. So, and for the requisites, in case the revocation was given by the person attacked, that the one making defense had no part therein. Number three, anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present. So, pwede ang stranger, no? And that the person defending be not induced by revenge, resentment, or other evil motive. Number four, any person who, in order to avoid an evil or injury, does not act which causes damage to another, provided that the following requisites are present. So first, that the evil sought to be avoided actually exists. Okay. Second, that the injury feared be greater than done to avoid it. No? So, kung ang injury daw, mas dako siya na mabuhat than that done to avoid it. So, kaysa imo siyang i-avoid. Okay. Third, that there be no other practical and less harmful means of preventing it. There is no other means to prevent, no less harmful means of preventing it. You could it could be categorized as justifying circumstances. 5, any person who acts in the fulfillment of a duty or in lawful exercise, so most probably mga police officers, of a right or office. 6, any person who acts in obedience to an order issued by a superior for some lawful purpose. One of the concrete example are those NBI agents. No. Next, we have, now what are justifying circumstances? So, ginabalik-balik yun siya because in the court, you have to prove nga it is part of justifying circumstances to exonerate you from criminal liability. No? Para dili ka mapriso. And you prove it to the court na it is a self-defense or it is in the performance of my duty. No? Kaya kung wala na ako siya gipusil, siguro ako ang mapusilan. But you have to take note that those three requisites present para ma-justify siya, para ma-include siya as justifying circumstances. Now, those wherein the acts of the actor are in accordance with the law and hence he incurs no criminal liability. So, ang tawag sa mga kon instead of accused is the actor because di man siya accused. No? Part na siya sa justifying circumstances, so lang siya criminal liability. And since there is no crime, there is no criminal, technically. Hence, they should not be called an offender, but an actor, okay? And therefore, no civil liability either. So that is why in Article 101, in cases falling within Subdivision 4 of the Article 11, the persons for those whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they may have received. So the civil liability is not on the actor in this circumstances. Now, the following are justifying circumstances. Okay, as I have said, defense of self, of relatives, and of strangers. Kung it is a defense or self-defense, or gidipin sa anime mong relatives, or even strangers, no? Then, state of necessity. Kinahanglan bagid kayo siya na mo kuanjud ka, mo pabuto jud ka sa imuhang pusil. Mao man siya nagpabuto. No? Fulfillment of duty. Okay? Obedience to superior order. So, those are justifying circumstances. Now, what are the requisites of civil defense? I mean, self-defense, civil defense. So first, we have unlawful aggression. Next, we have reasonable necessity of the means employed to prevent or repel it, and lack of sufficient provocation on the part of the person defending himself. So later on, we will go deeper one by one with these three requisites of self-defense. Kay ano siya pinaka-importante, one of the core of this topic. Now, self-defense includes defense of life, of chastity or property, and of honor. The latter includes defense against defamation. Unlawful aggression is indispensable not only for self-defense, but for the defense of relatives and strangers, as well as for without unlawful aggression. There is nothing to prevent or repel it. There can be no self-defense unless it is proven that there have been unlawful aggression on the part of the person injured or killed by the assailant. So to have a further elaboration of these circumstances, we have the case of People versus Posey.
Now, what is unlawful aggression? To constitute unlawful aggression, it is necessary that an attack or material aggression, an offensive act positively determining the intent of the aggressor to cause injury, shall have been made. And a mere threatening or intimidating attitude is not sufficient, and there must be a real danger to life or personal safety. To have a clear view of what is unlawful aggression, we have the case of People versus Nabaira. So it was promulgated last October 1991. And furthermore, unlawful aggression must be real or at least imminent. And real aggression means an attack with physical force. So kailangan may physical force, or with a weapon such as to cause injury or danger to life or personal safety. Now, if there is no weapon or there is no physical force, it could not be categorized as aggression. So kailangan meron talagang physical force. And there is a weapon para makakause ng injury. Kung wala namang weapon, like the fists could be an ultimate weapon to cause injury or danger to life or personal safety of a certain person. Imminent unlawful aggression means an attack that is impending or at the point of happening, and it must be offensive and positively strong. So kung hinay ra kaayo siya, like i-touch lang ka din ha, then there is no unlawful aggression or there is no aggression in that case. Now, when is there reasonable necessity of the means employed or kanang kinahanglan did kay siya pa? Wala, you have no choice but to act on this matter. So na siya reasonable necessity. Reasonable ang imuhang pag-act or pagpanumbag or pagpanagpa because this is to defend yourself. So kailan ba masasabi na there is reasonable necessity of the means employed? Now, the reasonableness of the means employed depends upon the circumstances surrounding the aggression, the state of mind of the aggressor, and the available weapon at the defender's disposal. So, for example, there is a gun, magitutok na sa imong baril, and then naibotilya sa imong kilid. And then, because kay nakuratan ka nga, naimong pusil sa imo nga, imong gikuha ang katong botilya niya, gihapak nimo sa iyang ulo. So that is reasonable necessity and that is allowed by the law. Dili ka pwede nga makasuhan ana. Because kailangan man nimo siyang hapakon to save your life, for your safety. So to have a clear view of this case, we have the people of the Philippines versus Gutwal. So it was decided by the Supreme Court last February 22, 1996. In self-defense, there should be necessity of the action taken as well as the means used. Kung wala na may reasonable necessity, for example, ang imuhang, like police officer, no? The concrete example, kung mag-arrest mo o certain criminal and you have this gun, kung walay gun, unarmed ang inyong i-arrest and then isukol siya sa inyo, nanumbag siya sa inyo ha, and then imo siyang gipusil, it could not be a valid self-defense. Imong gidepensahan kung na imong sarili mo, nang gipusil mo siya. So remember that the accused or the criminal is unarmed. So kailangan ang imuhang ibalo sa iya ha, to have a self-defense is fist-to-fist ba siya. So dili siya a reasonable necessity to have a valid self-defense in this case. Now, the latter requires a consideration of first whether the aggressor was armed. So, it was emphasized earlier. The nature and quality of the weapon used, and the physical conditions and sizes of both the aggressor and the person defending himself. Okay, so this is inculcated or defined in the case of People versus Nell. So reasonable necessity of the means employed to prevent or repel the unlawful aggression cannot be present when the unlawful aggression on the part of the victim has ceased. Okay. Next is the concept of lack of sufficient provocation on the part of the defender. Kana imo siyang gi-provoke, o sige, pusila ko, ingani-ngani. Diba? Siyempre, mapusilan jud ka because there is a certain provocation. Now, lack of sufficient provocation on the part of the defender shows that there may have been provocation, but it should not be sufficient and it must not immediately precede the act. The law requires that the provocation be sufficient or proportionate to the act committed and adequate to arouse one to its commission. It is not even enough that the provocative act be unreasonable or annoying. So it is not. So you have to take note na here it is not even enough daw that the provocative act be unreasonable or annoying, kanang gi-annoy lang ka. So it is not reasonable provocative act. So kailangan ang act of provocation is kanang napud siya weapon nga gi-provoke kaniya to kanang balusan nimo siya to have a reasonable necessity to defend yourself. So kung gianoy-anoy lang kaniya, o sige pusila ko ingani-ani, o sagpa ako ingani-ani. So it is not enough nga a valid self-defense nga o ingingnan mo ko niya nga sagpa mo siya. So kung gisagpa, it could not be raised as a defense later on in the court. Sufficient provocation as a requisite of incomplete self-defense is different from sufficient provocation as a mitigating circumstances. So later on, we will identify what is mitigating circumstances and what is aggravating circumstances. So from the word mitigating, i-less ni mo siya, no? Ang aggravating, katong itaas ni mo ang penalty o makataas sa penalty, mga circumstances. As an element of self-defense, it pertains to its absence on the part of the person defending, while as a mitigating circumstance, it refers to its presence on the part of offended party. To have a clear view of this definition or concept, we have here the case of People of the Philippines versus Court of Appeals. So it was decided by the Supreme Court last February 13, 2001. Okay, we have here the last article that we are going to discuss for this asynchronous class. The Article 12. This is one of the important provisions of the revised penal code. So you have to somehow memorize all of this or familiarize. It might out in your examination, and not only your examination, but as well as to your licensure examination for criminology. Now we have here circumstances which exempt from criminal liability. So in Article 11, it is a justifying circumstances to exempt from criminal liability. We have also circumstances that exempt you from criminal liability. Nga wala kay misang gamay nga criminal liability. But it will not exonerate you from the civil liability. The following are exempt from criminal liability. So number one, an imbecile or an insane person unless the latter has acted during a lucid interval. So kanang mga buang or kanang na-identify na ninyo nga buang siya and then she committed a crime like gidunggab niya nga sa ka-person. But since buang siya, known siya nga buang, she is exempt from criminal liability because that is stipulated in the law in Article 12. So kailangan kung naibuang, di gid ka magpaduol kay kabalo man ka ikaw man ang nasa lucid interval. Naman sa lucidity nimo, you're sane na makaharm gid siya sa people. So ikaw ang mo adjusts. Okay? But what if when an imbecile or an insane person has committed an act which the law defines as a felony, and the court shall order his confinement in one of the hospitals as asylums established for person thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. So what if nakakommit siya of crime, murder, and then syempre buang man siya, known siya nga buang, and then later on naayo na siya. Now the question is, ma-commit ba ma-filean ba siya og kaso as sa murder cases? Sige, padayon ako. Okay. So later on, nakitaan nimo nga naayo na siya. So, ma-exempt pa paghapon siya sa criminal liability? Yes, ma-exempt gyapon siya because the day nga na-commit niya ang crime, mo to siya ang reckoning period ang basehan sa court. Ang pag-commit niya og murder or heinous crimes, mo to siya ang basehan, dili ang katong pagkaayon niya during sa iyahang asylums in a certain hospital. Now, the question is, what if dili siya buang and then nakakommit siya og crime during that time, and then tungod kay na-stress siya, so nabuang siya. Now, the question is, nababa siya gihapoy criminal liability nga buang naman siya? Yes, of course, kay nahimo ni ang crime during the lucid interval. Kanang naa siya sa matinong pag-iisip, file gyapon siya criminal liability. Nagis pa siya criminal case. So dili mawala, dili ma-exonerate kung mapabuang-buang ng kadina. Diba? So number 2, A person under 9 years of age, kung makakommit, kung ang mga 9 years old, mangawat din na sa tindahan, they are exonerated from criminal liability. Number 3, a person over 9 years of age and under 15, so unless he has acted with discernment, when we talk about discernment, kanang na nasa sa iyang panimuot, kanang makadecide na siya kung saang wrong, kung saang right and wrong. But in most cases, syempre as a lawyer, di man yun na nila ingon dito no nga, o kabalo na siya na nasa iyang panimuot, no? And in which case, such minor shall be proceeded against in accordance with the provisions of Article 80 of this code. So, later on, you will know kung kano sila ma-convict. And usually, i-detailed siya or detain sila sa under DSWD because they are still minor. When such minor is adjudged to be criminally irresponsible, the court, in conformably with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education otherwise. He shall be committed to the care of some institution or person mentioned in said Article 80. Kung heinous crimes like mga murderous na mga intent, or na yung mga murder cases or mga rape cases, i-detain na siya sa DSWD. I-undercare na siya dito. Dili siya ihatad sa ihang parents. Pero kung mga light offenses such as theft or mga acts of lasciviousness or sa padiha nga mga light offenses, pwede ra siya nga i-kuan sa iyang family. So ang iyang family na karon ang liability, ang lookout sa katong mga 15 years old under. Number 4, any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. So there is no criminal liability while performing a lawful act with due care. No? Himo na nimong tanan. Or causes an injury by mere accident without fault or intention of causing it. So, for example, kanang mga driver sa bus. So, with due care, hinay ka sila padagan, and then, gina-check nila ang tanang makina kung okay ba. But, syempre, di na ito maiwasan ang mga accident na inibangga sa ilaha, pero they are on the right lane. So, naay mga nag-cause of injury or naay mga death during that time. Dili makasuhan ang driver because naman siya sa right lane and with acting in due care, and then it's just only a mere accident without fault or intention of causing it. But if ang driver is nagpakusog og dagan and then ni overtake sa other right lane and then naay accident kinahitabo, he will be liable, criminally liable, and also civilly liable. Okay, naman siya fault and negligence. Number 5, any person who acts under the compulsion of irresistible force. No? And then number 6, any person who acts under the impulse of uncontrollable fear of an equal or greater injury. So mga uncontrollable na mga fear or mga unequal or greater injury. Number 7, any person who fails to perform an act required by law when prevented by some lawful insuperable cause. Next, we have to identify or distinguish justifying from exempting circumstances. Now, in justifying circumstances, the act is legal within the bounds of law, and sa exempting, the act is criminal. And we have here also justifying circumstances. There is no crime, hence no criminal. And number 3, since there is no crime, there is no criminal and no civil liability. And number 4, the emphasis of the law is on the act. Now, in exempting circumstances, there is a crime and a criminal. And since there is a crime, there is a criminal, but exempt from criminal liability, and there is civil liability. The emphasis of the law is on the actor, okay, sa exempting circumstances. Next, we have, okay, what is insanity? So, kabalo naman siguro kung saan ang insanity, di ba? Exists when there is a complete deprivation of intelligence in committing the act. That is, the accused is deprived of reason, and he acts without the least discernment because there is complete absence of power to discern. Or there is a total deprivation of freedom of the will, or shall we say, mere abnormality of the mental faculties will not exclude imputability. No, that is the emphasize in people versus the noun. Okay, how are penal laws to be construed as to minor offenders? Now, penal laws should be liberally construed in favor of the offender. Kaning RPC, muna gina siya, pabor siya sa mga offender. Okay? Thus, considering the gravity of the offense in the interest of justice, the court has admitted the birth certificate of an accused to prove minority, although said birth certificates were not presented or offered in the trial court. Since the fact of minority established by an official document prepared by the DSWD and development in the exercise of its function and incorporated in the records of the case, judicial notice can be taken thereof. So ex miro moto. That is in the case of People versus Regalario. Okay. Now we have here amendment to the revised penal code. As I have said, na yung mga revision pero dili entire provisions of the revised penal code. We have here Juvenile Justice and Welfare Act of 2006 or Republic Act number 9344. The minimum age of criminal responsibility. So a child 15 years of age or under at the time of the commission of the offense shall be exempt from criminal liability. However, the child shall be subjected to an intervention program pursuant to Section 20 of this Act. And a child between 15 years but below 18 years of age shall likewise be exempt from criminal liability. So you have to take note that 18 years of age shall likewise be exempt from criminal liability and be subjected to an intervention program of the DSWD, unless she has acted with discernment. Now, in which case, such child shall be subjected to the appropriate proceedings in accordance with this Act. The exemption from criminal liability herein established does not include exemption from civil liability, which shall be enforced in accordance with existing laws. Now, what is the basis for exemption from criminal liability for accident? Now, under Article 12, criminal liability does not arise in case a crime is committed by any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. So you have to take note na he is performing or they are performing lawful act with due care. Okay, dili sa patakagdagan, hinahinay lang yun siya. The exemption from criminal liability under the circumstance showing accident is based on the lack of criminal intent. There is some criminal intent na kisabi gusto nga madiscuss siya, diba? For an accident to be exempting, the act has to be lawful. So when talk about lawful, walay mga traffic violations o wala na kuan sa beating the red light. No? The act of firing a shotgun at another is not a lawful act. No? Okay. Okay, that is our